Okay, let's see. Um, so the background to the report is that the AI Act relies quite a lot on the existence of effective remedies under other areas of law that are already existing, and it therefore is quite limited in its approach to effective remedies and what it covers in the law itself. But that poses, of course, for us the question to what extent this assertion that effective remedies are already covered by other areas of law is actually true, or whether there are certain gaps that are left by the AI Act not really addressing this issue. And that is why we looked at some of these legal frameworks, not all of them, but we focused on EU data protection law, in particular the GDPR, EU equality and non-discrimination law, EU consumer protection law, and EU product liability law in the form of the revised Product Liability Directive. As I already said, this is a non-exhaustive research, so there are, of course, a lot of other areas of law and legal frameworks that could come relevant and that can fill some of the gaps left by the AI Act, but which we couldn't cover in this report. But we would be very interested also to hear your views and perspectives on some of these other legal frameworks in the discussion. And then just very quickly on the methodology. So we mostly conducted desk-based research, building on the work that is already out there, but we also conducted interviews with 20 subject matter experts on the different areas of law that we focused on. Yeah. Okay, now it seems to work again. So, as I already mentioned, the AI Act does not really address the issue of specific remedies, but relies on existing EU and national law, which, according to the AI Act, already covers this issue. And that is why, under the AI Act, you basically don't really have a lot of focus on effective remedies. So, you have the right to complain to a market surveillance authority, and you have the right to an explanation. But these are both severely limited and have several shortcomings, which I won't go into much detail now because this will be part of the second presentation by Ernestina. But just in general, you don't have any right to compensation in case of harm under the AI Act and no right to redress in general. And apart from these very specific shortcomings of the AI Act in terms of effective redress, there are also just some general shortcomings and limitations of the AI Act that limit its usefulness in the context of having an effective pathway to effective redress. So there is, for example, the issue of uncertainties and unclarities regarding the definition of an AI system and therefore the scope of what the protections under the AI Act cover. And related to that, there is the possibility for providers of high-risk AI systems to self-assess themselves out of the high-risk obligations. And then we have a lot of the prohibited practices and also high-risk use cases that are riddled with loopholes and exemptions for national security reasons or in the context of migration, law enforcement, asylum, border control, and so on, which also seriously limits the added value of the AI Act in that regard. So our conclusion was that the AI Act on itself does not provide for effective remedies in case of AI caused harms. Okay, so now my slides are not moving again. Okay, I'm gonna stop sharing and resharing. Hopefully it will work. Maybe I'm just gonna present them like this. So yeah, based on this conclusion that the Act itself does not provide for effective remedies, we actually went through these different other legal frameworks. I'm going to now in the presentation focus on one main strength that we discovered and one main gap or challenge that we identified. The report goes into more detail and enumerates some more. But just for reasons of time, I'm going to focus on one. So starting with the General Data Protection Regulation, the main strength that we identified is that it is a fundamental rights-based instrument, which is technology neutral. So issues like the limitation of scope for AI systems or high-risk AI systems would not apply here. And it lays down both judicial and non-judicial pathways to effective remedies. It includes quite a lot of data subject rights on which individuals can rely and which individuals can invoke. But then at the same time, especially the non-judicial pathways to redress and enforcement actions are seriously limited by the resource constraints of data protection authorities, both in terms of human and financial resources. And then also cross-border enforcement procedures are quite challenged and have quite some limitations due to the one-stop shop mechanism. So meaning that one lead data protection authority is responsible in cross-border cases, which makes these processes quite cumbersome and lengthy and also quite dependent on the goodwill and the actual, powers of one data protection authority, which in the past led to some of the outcomes leaving much to be desired. For equality and non-discrimination law, one of the main strengths we identified is that it actually starts from the premise that there are asymmetries of power between the affected individual and the perpetrator, and that there are certain tools and instruments in the law that try to rectify this imbalance of power. And one of this is the shift of the burden of proof in case where the affected individual can establish an assumption of discrimination, and then the burden to prove that discrimination did actually not happen shifts to the defendant. And this is very useful in the context of AI, or where AI is involved, due to the intransparency, the opacity of AI systems, and just the individual often not really having knowledge and understanding about how a decision came into being, what factors influenced it. And that can be very useful then to help the individual in such cases. At the same time, equality and non-discrimination law is limited by its strong focus on individual redress and individual litigation, which puts quite some burden on the affected individual to bring a case, which is problematic due to the costs of proceedings, the time that takes, also the mental load that takes for individuals. And actually, even though the shift of the burden of proof helps, it is often not enough for individuals to actually bring a good case and make a strong argument due to the opacity of AI systems. And then at the same time, individual litigation is also limited in the sense that it cannot, or only to a certain extent, address the structural and systemic nature of algorithmic discrimination or just of structural discrimination in general, which, however, is responsible for much of the bias we see in AI systems and which can therefore not just be addressed through individual litigation. Speaking about the limitations of individual litigations, one of the main strengths of consumer protection law that we identified is that it actually has a clear possibility for collective redress under the Representative Actions Directive, which can therefore address many of the shortcomings of individual litigation, and also specifically in the context of AI, where we see that many of the infringements are quite widespread or quite systemic and at scale in their nature and affect a lot of individuals at the same time and not just one individual. At the same time, given that it's a directive, the added value of the Representative Actions Directive is very much dependent on the implementation in the member states. According to the directive, member states have to take measures that the costs of representative actions does not prevent qualified entities from bringing such claims, but actually in practice, this is still a big issue and costs are really high for qualified entities. And apart from specific means that member states need to do in order to address these high costs, there are also just some general implementation procedures that they could put in place in order to reduce the cost. So, for example, under the directive, you have the possibility to provide for an opt-in mechanism, meaning that any affected individual that wants to become part of an action needs to actively sign on to that action, which puts a strong burden on qualified entities in terms of costs, in terms of time to actually sign every individual onto that complaint. or you can opt for an opt-out mechanism where only the individuals that don't want to be part of the complaint need to actively say so, which would be much better in terms of costs and burden for qualified entities. But that depends on the implementation by the member states. And then finally, looking at the revised product liability directive, which can be a very useful instrument to get compensation for harms in the case of a defective AI product. Also, in the absence of the AI liability directive, the proposal of which was withdrawn by the European Commission last year. And one of the main strengths of that law is that it also has some provisions that cater for the asymmetries of knowledge and information between the affected individual and the perpetrator. So there is the disclosure of evidence mechanism where the affected individual in front of court proceedings, after it has submitted sufficient evidence and fact to sufficiently support the plausibility of a claim for compensation, and then the court can order that the defendant needs to disclose relevant evidence. And if the court thinks so, it also needs to disclose that in an understandable and accessible manner, which can again be very useful in these cases where information is not in the hands of the individuals, but actually with the defendant. However, while this looks good on paper, in practice it is also quite limited. So first of all, this disclosure of evidence mechanism is limited to court proceedings. However, individuals would need already quite some information in order to actually decide whether they have a valid case and whether that case is likely to succeed before they even start court proceedings. And then also many of the cases under the old product liability directive were actually decided in out-of-court proceedings. And so for this, the disclosure of evidence mechanism would not be really useful. Then the disclosure of evidence mechanism can be subject to abuse and misuse by defendants. For example, if they artificially prolong proceedings by just producing a lot of information and documentation, and then the court and the affected individual need to go through all of that information to filter what is actually relevant and needed. And then finally, it is, of course, also only useful where the defendant is in possession of all of this extensive documentation, which would, for example, be the case for high-risk AI systems under the AI Act, but not in other cases. So based on the assessment of all of these different legal frameworks, we identified some common gaps that kind of run as a red thread through all of these areas of law. So first of all, we really saw that the opacity, the lack of transparency, and the understanding about the functioning and the use of an AI system, to what extent an AI system was used, what factors played into it, what data was used, and so on, make it really difficult to bring cases for individuals and make it really difficult for individuals to bring cases that are likely to succeed. Connected to that are the limits of individual litigation, which I have already mentioned in the context of AI, harms that are widespread, affect a lot of individuals at the same time. Something that also came up in all areas of law are the costs and the length of proceedings, especially if expert advice is needed, which is very often the case in these very complex cases involving AI. Another issue that always came up was the lack of financial and human resources for enforcement bodies and administrative authorities, also in light of the increased expertise they need to decide on these cases or to make judgments in these cases, but also in light of new powers and tasks they get under legislation such as the AI Act, which is, however, not always coupled with more resources that they get. And then finally, we identified a lack of harmonization of some of the rules, but also of some of the enforcement structures, which leads to an uneven playing field and challenges in cross-border infringements, which are quite common in the context of AI. Based on that, we developed several recommendations in general for EU law in the context of effective remedies for AI-induced harms. So first of all, given the limits of individual redress that we have seen, it would be vital to strengthen collective redress mechanisms. So on the one hand, this would mean strengthen or ensure rights enabling a strong implementation of the Representative Actions Directive, but then also strengthen other collective action mechanisms under other laws, such as Actio Popularis under Equality and Non-Discrimination Law, or collective redress under the GDPR. It would be vital to ensure adequate financial and human resources for enforcement authorities and for administrative bodies. And here also increased tasks and powers under legislation such as the AI Act should go hand in hand with more resources. We need to ensure ongoing capacity building and training for staff at enforcement authorities and judicial bodies to build their literacy on AI and the impact it has on fundamental rights and effective remedies. And given the many procedural challenges we have seen in the context of AI and effective remedies, we would need to introduce procedural safeguards such as a reversal of the burden of proof. Continuing, we need to ensure that transparency provisions actually ensure the provision of meaningful and understandable information that can enable and empower individuals to act upon their rights and to enforce them, and not just be a ticking the box exercise. Throughout the report, we have seen that there are quite some discrepancies with regard to the extent to which material and non-material harms can be redressed. However, given the serious impact that AI can have on rights such as privacy, data protection, non-discrimination, but also mental harms, for example, it would be vital that non-material harms can get, for example, compensation to the same extent as material harms. And then, given the limitations we have seen with regards to the revised product liability directive, it would be vital to propose a new AI liability directive that would address the previous proposal's shortcomings. And finally, the upcoming Digital Fairness Act proposal provides quite an important opportunity to safeguard some of the AI-specific procedures that would be helpful to address AI-induced harms. And then we also came up with some specific recommendations on the AI Act in terms of effective remedies. So first of all, it would be necessary to provide more guidance and clarity on the right to an explanation to make this actually a useful right for individuals to rely upon and to use. It would be necessary to set baseline requirements to harmonize market surveillance authorities' procedures to make sure that individuals can rely on the same pathways to redress in all member states. We also need to improve regulators' preparedness to deal with the vast range of actors deploying AI, so not only economic operators with whom they might have some more experience, but also, for example, public authorities. And then we would need to develop pathways to hold market surveillance authorities accountable at judicial level, which is currently not possible, but would, however, be vital in order to ensure effective oversight of their role and performance, such as is, for example, possible under the GDPR. And finally, under the AI Act, there are quite some bodies that can fulfill multiple roles at the same time. So, for example, being a fundamental rights authority, being a data protection authority, a market surveillance authority. So it would be vital to provide more clarity for how these bodies can effectively fulfill these multiple roles. Related to that, the AI Act also foresees quite a lot of different institutions and authorities that are involved. And it does, to some extent, provide some pathways for cooperation between them, but we would need just some more clarity and some more guidance on how to ensure interinstitutional cooperation. For example, cooperation between market surveillance authorities, how disputes between market surveillance authorities can be resolved, and so on. And then finally, in the absence of effective remedies or specific effective remedies under the AI Act, there is the possibility for individuals to bring private enforcement actions for infringements under the AI Act to actually get redress for harms. However, in order to be sure whether to what extent this is possible, more research and analysis of this would be necessary. So this was our report in a nutshell. Please feel free to ask any questions after the second presentation we had. So I'll pass it over to Ernestina now.
Thank you very much, Magdalena. Okay, could you hear me? Okay, thank you very much. I'm sharing my screen. Hope. Okay. I'm sorry, I don't know why, but I'm coming back with you, I hope. Just a minute. Could you see my screen?
Yes.
Okay, but it doesn't work. Also for my case, just a minute. I will try to present. Also, in my case, I will use this modality. Okay. Let's go. So I'm Ernestina Sacchetto, research fellow at the University of Turin and criminal lawyer, specialized in the field of the use of new digital technologies for law enforcement purposes. Thank you very much, Laura and CDT, for the great organization of the event. Today, I will present the key arguments and findings of our policy paper entitled Ensuring Rights in the Age of Artificial Intelligence, which analyzes the system of safeguards, remedies, and enforcement mechanisms introduced by Regulation 2024-1689, commonly known as Artificial Intelligence Act. So, as anticipated, this policy paper was produced by the Hermes Center and the Good Lobby as part of the Your Face, Your Rights project founded by the European Artificial Intelligence and Society Fund. The aim of our policy paper is to highlight the topic of redress mechanisms. And as you already probably know, this term generally refers to any procedure that allows an individual or a legal entity to challenge a violation or an outcome of an artificial intelligence system, question the decision-making logic, or obtain some form of redress or correction for the negative effects that have resulted. So the aims and our scopes that we started to focus on were exactly to examine what are the legal actions for citizens in case of a violation of a European rule, of course, covered by the Artificial Intelligence Act, to clarify what are the responsibilities and duties of the competent authorities at the national level to ensure the correct application of the regulation, and then in the end to propose our policy recommendations to decision makers in order to facilitate the full implementation of the European rules. But we have to say that in the context of artificial intelligence, redress could include several rights and possibilities. the right to challenge an artificial intelligence-based decision, the right to obtain a meaningful explanation, the right to lodge a compliant with a competent authority, and where appropriate, the right of judicial remedies and compensation for damages. This is the context, the general context of artificial intelligence. But we have to look at the regulation, the new regulation, so the Artificial Intelligence Act. And we asked to ourselves, how can individuals, citizens, common people, effectively protect their rights in case of an infringement of the rules of the regulation? This question, I think, becomes particularly urgent as an artificial intelligence system and artificial intelligence systems in general, I would say, are increasingly deployed in high-impact domains, such as, for example, law enforcement, biometric identification, public administration, employment, and the access to essential services. So, we decided to put several examples in our policy paper in order to give concrete meaning to the abstract rules put in the regulation. In particular, we focused on Article 85, Article 86, Article 87. And for example, we put the example of a company operating in the logistics sector, which uses software, of course, artificial intelligence software for the optimization of the system. This software is covered by the Annex 3 of the Artificial Intelligence Act, and in front of a denied request to obtain adequate documentation regarding the systems, what is the specific remedy of the Artificial Intelligence Act for our citizens in order to obtain this documentation that, as probably you already know, being a high-risk system, has to be compliant to the Article 6 and following. So we need a specific documentation about this specific software. Article 85 of Artificial Intelligence Act formally recognizes the right of any natural or legal person to lodge a compliant to the National Market Surveillance Authority when they believe that the regulation has been violated without prejudice to other administrative or judicial remedies. I think that this is completely aligned with the second recommendation for the Artificial Intelligence Act of my colleague Magdalena on the possibility to set baseline requirements to harmonize market surveillance authorities' procedures. Because substantially, Artificial Intelligence Act does not address the issue of specific remedies, specific proceedings, relying instead on existing EU and national law. So member states, European member states, will have to introduce at the national level a specific proceeding in order to be compliant to the regulation. So Artificial Intelligence Act put the general rule, but without giving us a specific proceeding to be followed. And we decided to look at other European legal framework in order to understand if there are other specific European rules in which this is not present. This specific approach is not present. And we found that, for example, also for because the sector is closer to artificial intelligence, under GDPR, people know exactly how to complain, within which time frame, and what remedies are available, including the damage compensation proceedings. So the example of GDPR is more specific than Artificial Intelligence Act, in which specific procedures are undefined and coordination between authorities remains unfortunately unclear. And this, of course, you can imagine could create the high risk of fragmentation at the national level, because European member states will introduce at the national level several, this is our hypothesis, of course, but several different legislations on these specific proceedings, with also the possibility to have different levels of protection of the same rights. And this is for Article 85. Another key pillar of our analysis concerns Article 86 of the Artificial Intelligence Act, introducing the right to obtain a meaningful explanation. I would say that this is not a real new introduction of this right, because already with GDPR we had this kind of protection, but with Artificial Intelligence Act we have a step forward. And we have the possibility to lodge a compliant, to have a meaningful explanation, asking to market surveillance authority. So at the national level, we have to lodge a complaint to the National Market Surveillance Authority. So the right is covered by the Article 86. The instrument is present, is covered by Article 85. And for the interpretation of meaningful explanation, we have to look at the guidelines on prohibited artificial intelligence practices, which put several requirements and criteria in order to consider a meaningful explanation as expressed by the Article 86. So the role played by the artificial intelligence system, the criteria used, the data involved, and whether errors or biases occurred. But again, we have an expression, of course, of the right here, but we don't have a specific procedure to be followed in order to contest or to challenge an automated decision making. Also in this case, again, we put examples in our policy paper in order to give a a concrete meaning to our premises, but also our conclusions, and in order to be more comprehensible, understandable to citizens. So in case of an automated decision making, what is the specific remedy that citizens could ask, could have in order to obtain protection. And our conclusion is that the right is covered under the umbrella of Article 86, but the means, the tools, the legal tools are under 85, Article 85. Of course, this is particularly relevant, as you can imagine, when we are speaking about biometric identification, automated screening, predictive systems, or decision support tools used by public authorities. But of course, the effectiveness of the protection of the right in Article 86 again depends on national implementation and on the technical capacity of the authorities to access complex artificial intelligence systems. So we also mentioned in our policy paper a clarification on Article 87, and again, Artificial Intelligence Act, in this case, just recalls the protection put in the Directive 2019-1937 on whistleblower protection, recalling the importance of internal reporting mechanisms in the context of artificial intelligence is, of course, fundamental. This kind of protection cause developers, engineers, public officials, or private employees may be the first to detect harmful uses of artificial intelligence systems. But in the Artificial Intelligence Act, we have just a recall of this protection, not a specific procedure that we have to follow from a legal point of view at the national level. And what happens in case of harms? We also asked to ourselves, in case of harms for a violation or for a wrong use of an artificial intelligence system, we ask to ourselves if Artificial Intelligence Act is giving us a sort of protection or European rules. And unlike GDPR, as my colleague already mentioned before, Artificial Intelligence Act does not contain any specific liability regime. So victims of harms must rely on the recently amended Product Liability Directive or the existing law, for example, GDPR, or again, national civil liability rules. The good part of this directive, because the first idea, as you know, was to introduce at the European level a specific artificial intelligence system liability directive, but without agreement between European member states, this directive was retired, And the possibility was just to amend this product liability directive. The good part of this amendment of this directive was to extend the application of this directive to digital products and artificial intelligence components. This directive also with the amendments introduced an easier burden of proof. So victims could ask protection in an easier way in order to have a compensation for harms. But as my colleague explained very well before, there are still limits. For example, for immaterial harms, we don't know if they are covered by this directive from a legal point of view, or it remains difficult to identify for individuals the correct responsible actor along the value chain. So there are limits. There are still limits. So our analysis concludes that the following measures can be taken to uniform and to create a clear procedure at the national level. And we suggested several recommendations. First of all, we suggested the adoption of a standardized national compliant procedure. For example, we put a sort of timeline, ex Article 85, for example, 5 to 10 days for a registration of a case, 30 days for preliminary assessment in order to understand if a request based on Article 85 is admissible, or 60 days for a decision on the merits or adoption of interim measures. We suggested also to introduce rules on form, evidence, deadlines, and remedies in case of denied request. And then a stronger coordination between market surveillance and fundamental rights authorities. The introduction of a public case register, anonymized, open, and interoperable. And then to ensure an effective protection, also the introduction of remedies for material and non-material harms. Of course, in a very deep way, we articulated, we wrote this policy recommendation for policymakers. Of course, in the end, further research on the possibility to uniform provisions of the Artificial Intelligence Act at the national level is one of the main suggestions that we pose in our premise. Just to conclude, Artificial Intelligence Act is an historic step in regulating artificial intelligence. The protection of fundamental rights will be effective only in the case the redress mechanisms are put in place. In a period where automated systems increasingly shape life, chances, opportunities, and freedoms, ensuring meaningful remedies is not just a legal necessity, but a democratic imperative. And we would like to express our sincere appreciation to all participants who registered for and attended the webinar, contributing to a stimulating and engaging the discussion about our report. We remain absolutely available to address any further questions or requests for clarification. Thank you very much for your attention.